EPGD attorneys at law. We're gonna do a 5-minute video. We're gonna break down an interesting fact pattern right out of real life. And so here's what happened. 7 years ago, my firm and my team drafted a lending agreement for a company. Now, this company specifically targets lending in Latin America. Now, the borrowers are in Latin America, but what they did is they wrote a contract that was gonna be enforceable here in Florida. And more specifically, it was gonna have Florida law, Florida jurisdiction, and Florida courts. And these are all consented to by the borrower. So the borrower, in exchange for the money that they want to get, had to sign personal guarantees. They had to give a collateral. In this particular story, it's going to be boats. We're actually very nice, large fishing boats. And that was going to be the collateral. The individual borrowers were going to be personal guarantors. And then the company that was borrowing the money was down in Latin America. And they were going to consent to do all of this in Miami-Dade court, in Miami-Dade in front of a judge if anything went wrong. And so a lot of times, if you're the lender, you need to make sure that you have a really good lawyer drafting these contracts for you, because you need to make sure that if anything goes wrong, which basically you're losing money, that you are going to be protected for your attorney's fees, that there's going to be collateral, that there's going to be personal guarantors. I don't want to be able to just go after some LLC or some corporation that might be a shell company and it might have no assets underneath it, and they might just close it or walk away from it. And unless there's a personal guarantee, then I won't be able to go after the individual owners in most situations. Now, I've done other videos over the years about how to pierce the corporate veil, but we won't go into that. I will just say that when you sign a personal guarantee, you've automatically consented to piercing the corporate veil. So we can skip that whole analysis of how to convince a judge to go after the owners. They've already agreed to it. Now, here's the situation now. So the contract was drafted in 2018. It was entered into in 2019. The payment was due in 2020, 2021, and 2022. After the payment number one in 2020 was missed, the lender sent a notice of default. Well, now here we are in Q2 of 2025, and my first concern, and this is a real concern, is what's called the statute of limitations. Now, that's statute with a T, not like the famous Seinfeld episode where Kramer thinks it's statue, like the David in Florence. No, this is statute with a T, which is another word for law, right? So this is the law of limitations, meaning that there's a certain window, a time frame that you can bring certain lawsuits. Now, there's different types of statutes of limitations for example, medical malpractice claims, insurance claims, property claims, personal injury claims, fraud claims. And so every state, so for example, if you're in California, the statutes of limitations are going to be different than if you're in Florida or Texas or New York. So you need to be specific. Now, if you're suing under a contract and the contract says Florida law, well, I can tell you that a written contract has a 5-year statute of limitations. An oral contract might have a 4-year statute of limitations. You might have other statutes of limitations if it's under other specific types of laws. So this is very important. So if you, in this case, are the lender, or if you're entering into a contract, or you just need to know what is the limitation. So to put it another way, if someone screws you over and someone owes you either goods or services or money in this case, you need to make sure that you're aware of what the time frame is on when you can bring a lawsuit. And the reality is, if you miss that window, you might be out of luck. There might be nothing you can do. And there's a reason for that. The law wants certainty. So if somebody breaches a contract 20 years ago, the law doesn't want people digging up these 20-year-old cases and starting a lawsuit today. And there's a lot of important reasons. What if the witnesses are gone? What if the evidence has been destroyed or damaged or removed or misplaced? And so at a certain point, we need finality. So if somebody defaults on a contract and you wait 5 or 6 years to do anything on it, the law might say, sorry, you had 5 years to do something. So especially if you're, in this case, a lender, make sure that you're aware of the statute of limitations. Make sure that you're aware of issues such as latches, which I'll talk about in another video, and make sure that you haven't waived any sort of rights that you might have. And then conversely, if you're the borrower, you need to be aware of what the statute of limitations is. And maybe if you reset the statute of limitations, such as by making a payment on a debt. So these are all deep questions. We could write never-ending law school essays on the answers, and there's probably questions on the Florida bar. But if in your case, if you are a lender or a borrower, make sure you know your statute of limitations.